former Fulbright scholar, and he is the professor of law at Mitchell Hamlin School of Law. He's an expert in medical law and clinical ethics, and I think we can sort of say just straightforwardly, this is shown by a number of things, not least of which his being named as a Hastings Center Fellow. The Hastings Center describes itself as the preeminent New York-based bioethics research institute and think tank, probably so they don't have to fight it out with the NIH and Hopkins and Georgetown down in the Baltimore, Washington area. But they were founded in 1969. They sort of were instrumental in establishing the field of bioethics, and consequently, being a Hastings Center Fellow for a bioethics scholar is a tremendous honor. Dr. Pope focuses on patient rights, healthcare decision-making, especially at the end of life. But at a recent conference of the American Society for Bioethics and Humanities, I saw the former president of the ASBH, Alexander Kahn, introduce him to his son as, if I recall correctly, the expert in everything. While Dr. Pope probably doesn't want to have to live up to that, if you look at his list of publications in his areas of consulting expertise, I think he comes awfully close. He has hundreds of law, medicine, and bioethics publications. He's highly cited, and he co-presents annually at the ASBH a session that's on my never miss list, where he covers the legal highlights and lowlights in bioethics of the previous year. Before all of that, he was a JD PhD student at Georgetown University at the same time that I was earning my PhD there. And if you think that means I'll tell you embarrassing stories about him, you are wrong, because he could return the favor and I would lose. So without any further ado, let me close my share so that he can begin his, and let me introduce Dr. Thaddeus Pope.
All right, thank you, Stephen. Just hold on, I'll just get this. Just gonna, okay, thanks. There's the QR code. I think I put it again at the end of my slides in case you missed it. Thanks, Tulane, for having me. So I called this, as you saw, dead donor rule violations are rampant, brain death, DCD, and NRP. That's me. I don't have anything to disclose, but I do want to say that I am pro-donation. I am a first person authorization donor with a designation on my Minnesota driver's license. There it is. And I want to say that I strongly, about 1 year ago in South Carolina, I strongly defended first person authorization, and specifically LOPA in its enforcement of FPA donation. But let's get started. This is Guy Alexandre, right? One of the original transplant surgeons in the early 1960s. He died just a few weeks ago and had obituaries in a lot of the leading newspapers around the world. One of those obituaries started like this. He removed the organs of hundreds of his patients before they were declared dead. Colleagues thought that he was committing murder. So, right, the normal rule is you're supposed to determine death, then remove the organs. And the concern of Dr. Alexander's colleagues was he was going in the opposite direction, where he was removing organs, then the patient died. So we're going to talk about violating the dead donor rule. Now, we've seen in the press over the last few months a number of close calls at U.S. airports where two planes almost collided. Well, we have the same thing in organ transplantation, where we almost took organs before the patient was dead. This is the case of Zach Dunlap, well covered in the media. This is some cases in the Los Angeles Times about close calls. There's a case in New York, patient awoke as docs prepared to remove organs, and a number of other cases in the medical literature. Those are all what we would call accidental dead donor rule violations, or almost violations. But what we're going to talk about today are deliberate, intentional violations. And I want to say that penalties are being imposed for these violations, and I want to give you a few examples of that. First, In China, of course, for many, many years, we know that they have executed political prisoners in order to transplant those organs, right? That's been the subject of UN inquiries. It's been the subject of US congressional hearings, including hearings just a few weeks ago. And it's well covered in the medical literature as well. So that's China, right? There's this movie which Claude Van Damme, right, where the prison executes its own prisoners in order to sell their organs for profit. But at least in China, it's not just in the movies. Another example is in the state of Kerala in India. Recently, a court issued a summons to a hospital and 8 doctors because they had taken organs before the patient was determined dead. There's also a civil suit brought by the family, although the civil suit's on hold, so the criminal case can go first. And just a few weeks ago, they reported that they expanded the inquiry here because the recipient was a foreigner, which suggests that this was trafficking for profit. And then a third example in Brazil, this boy fell off a balcony. They took his organs before he had properly been determined brain dead. And at least one doctor has already been sentenced to 21 years, and 5 more clinicians have ongoing criminal prosecutions. So those are just cases from around the world. What about right here in the United States? Well, we could go back to 1968 to Richmond, Virginia. This transplant surgeon famously was the subject of this lawsuit, Tucker versus Lower, in which he was charged with taking the organs of this patient, Bruce Tucker, before he had been determined dead. And that's actually the subject of a best-selling book, The Organ Thieves. And just a few weeks ago, weeks ago, the Virginia State Legislature passed a resolution apologizing for that act because it had been done at a state hospital. And in fact, that case was the motivator of enacting brain death laws in the 1970s so that transplant surgeons could say the patient was dead before they took the organs. Now, yes, that case, the Tucker case, is old. It's from the very beginning of the timeline of transplantation. What about more recent cases? Well, let me give you a few of those, right? Here's a case from San Luis Obispo, California. The transplant surgeon, Houghton Rusrock, was summoned down to a hospital to obtain the organs of Ruben Navarro. This was a DCD case, but after they withdrew life-sustaining treatment, the patient, Ruben Navarro, didn't die. His heart didn't stop. So the transplant surgeon, Dr. Rusrock, administered 220 milligrams of morphine, 84 milligrams of Ativan. One of the nurses reported this to the police. And Dr. Rusrock is charged and prosecuted. And this is the way the district attorney put it in San Luis Obispo County. The defendant, a transplant surgeon, administered excessive amounts of narcotics and tranquilizers to hasten his death so that he could harvest his organs. Now, ultimately, the jury acquitted Dr. Rusrock, but I should note, right, this trial took 2 months, long trial, and altogether, with the investigation and everything, this took 3 years out of Dr. Rusrock's life, right, imposing a pretty significant personal and professional burden. Another case from Erie, Pennsylvania, this is the OPO in that area, and this is a donation after brain death case. This is the patient, Gregory Jacobs. He had an accident skiing while on a school trip. But he had serious neurological damage, but he wasn't brain dead. His parents sued, alleging that the clinicians either hastened his death or started transplantation before the determination of death. And that case settled for $1.2 million for the parents. And then a third case, this transplant coordinator who worked for this OPO in New York alleged that the OPO regularly took organs from living patients. In fact, he said as many as 1 in 5 of the organs the OPO obtained were from living patients. So those are just 3 cases. There are others. We don't have time to, this is an ongoing case in North Carolina. This is an ongoing case against the Mississippi OPO that's active. But the take-home message I just want to start with is that the dead donor rule really is being enforced. I'm sort of tempted to recite the lyrics from the TV show Cops, right? Bad boys, what you gonna do? What you gonna do when they come for you, right? The dead donor rule has teeth. And we see this a little bit because you see a lot of US hospitals afraid to participate in NRP donation. And we'll get back to that. So I am a law professor, as Dr. Hansen mentioned. So I want to give you just one more case. This is the case of Munchkins versus Wicked Witch of the East, right? You might recall from The Wizard of Oz that there's this tornado and it picks up Dorothy's house and it lands on the Wicked Witch of the East. You see the ruby slippers there. Basically, right, a blunt force trauma to the head, killing the Wicked Witch of the East. The Munchkins celebrate and they sing, ding dong, the witch is dead, the witch is dead, the witch is dead. But then the Munchkin mayor comes out and he says, hold on, guys, wait a minute. We've got to verify it legally to see if she is morally, ethically, spiritually, physically, positively, absolutely, undeniably, and reliably dead. So they bring out the Munchkin coroner here who examines the Wicked Witch of the East, and then he confirms she's not only merely dead, she's really most sincerely dead. So what's the point of this case? Well, we need certainty and clarity, right? The line between life and death needs to be bright and clear and sharp, and it's become a little bit fuzzy and gray, right? We need to know if the patient is alive or dead. And US clinicians do make lots of medical errors, right? We have 5 big reports on that. Goes back all the way to 1999, right? With the Institute of Medicine to Err is Human. Found that there's 98,000 deaths every year from preventable medical error. Made into a nice documentary. In 2010, the Office of Inspector General of HHS doubles that, says there's 180,000 deaths every year from preventable medical error. And that's just deaths, right? Doesn't even count injuries. And it's just Medicare beneficiaries in a hospital setting. So it doesn't count all the other patients with other types of insurance. In 2013, we get this study, which says now there's 400,000 premature deaths from medical error. In 2016, this BMJ study, 250,000, although it said it's probably low. And then in 2023, the New England Journal of Medicine finds a very high rate of adverse events in US hospitals. A lot of different studies. It doesn't matter which one we use. Whichever one of those numbers we use, it's way, way too many. And if we put it in context, means that medical error is the 3rd leading cause of death in the United States after heart disease and cancer. Let's just contrast that rate of medical error generally with death determination specifically. With death determination, we want 100% accuracy. We want 0 false positives, 0. We never want to say that somebody's dead when they're not dead, because it's really a scary sort of thing, right? And it's been scary for like 100 years. Back in the 1800s, people really, there was a big fear, taphophobia was a big problem. People were afraid of being buried alive. This is captured in this Edgar Allan Poe book, The Premature Burial. So during this time in the mid-1800s, we invented lots of tools and instruments to make sure that the person was dead before we buried them. So we'd pinch them with this pincher thing. Or we'd get tobacco smoke and blow it. This is where you get the expression blowing smoke up your ass. Or this one where we tie a string to a bell, right? So if the person woke up in their coffin, they could pull the string and that would ring the bell back up on the surface, and then we could dig you back up. This is where you get the expression saved by the bell. The point is, we never want to say that somebody is dead when they're not dead, right? And that's especially true in the context of donation transplantation. That's why we have the dead donor rule. We never take vital organs until after the individual has been determined dead. But we're not so good at following the rule. So here's the roadmap for the next 35 minutes in 4 parts. First, quick review of organ transplantation, the dead donor rule. I'm going to describe 4 violations of the dead donor rule, and then what can we do about that? So organ transplantation, we already know this, right? There's a gigantic waiting list of people waiting for organs, right? 17 people die every day waiting for an organ transplant. We can get organs from living donors, and we can get them from deceased donors. Most organs are from deceased donors, right? Last year in 2023, we got 7,000 transplants from living donors, but 40,000 from deceased donors, right? So only 15% of transplants came from living donors. All the rest, 85%, came from deceased donors. So I'm just going to put living donation aside. Today, we're going to focus on deceased donation. And that brings us to the dead donor rule, right? Procure vital single organs only from donors who are already dead. Sometimes this is codified into law, like in Maryland, where the statute says pronouncement of death shall be made before any vital organ is removed for transplantation. Even in Louisiana, the state legislature has recognized that, quote, the dead donor rule protects the integrity of human organ donation by providing that donors must be dead before procurement begins. And organ procurement itself must not cause the death. But even where it's not codified into law, the dead donor rule really sits at the center of transplantation ethics, right? And we wrote about this in a consensus forum last year. You go all the way back to 1968, the original transplant surgeons didn't follow the dead donor rule, which really prompted the invention of brain death, right? So that we could follow the dead donor rule. But there's a second way in which the dead donor rule sits at the center of transplantation ethics. And I want to use an analogy here, which is the White House had a problem for a while of people jumping the fence, right, and getting onto the lawn, the front lawn of the White House. So what the White House did was they put up this second fence, right, in front of the main White House fence. Well, we did sort of a similar thing with the dead donor rule. We built sort of a second fence. And you see this in the way the World Health Organization, in its guiding principles, articulates the dead donor rule, right? And it says physicians determining that a potential donor has died should not be involved in transplantation. So there has to be a separation between the determination of death clinician and the transplant clinician. And this is also built into Louisiana law, right? The physician who determines death can't participate in removing or transplanting the organs, right? We don't want any one clinician to be pulled in 2 separate directions at the same time, right? So we draw this extra line around the dead donor rule to screen out conflicts of interest that might cause dead donor rule violations, right? So what we're doing is it's not only that you need to follow the core dead donor rule, but also you have to avoid even the appearance of impropriety, even the risk that you might violate the dead donor rule. And let me take it one more level, because I think the dead donor rule might be stated even more strongly still in a third way, which is the concept of burden of proof, which is it is after all the dead donor rule. It's not the probably dead donor rule. And we're presumed alive until that presumption is rebutted. Now, it's obviously, I think, rebutted in the case of perhaps guillotine or decapitation. But otherwise, you need to have a very high level of confidence in evidence to prove that the person is dead. So that's the dead donor rule, right? First, determine death, then take the organs. And if you don't follow it, as the transplant surgeon character in this Denzel Washington movie put it, if you don't follow it, then you cross the line. So when exactly are people dead? Well, there's 2 ways to be dead. The Uniform Determination of Death Act, the UDDA, which is the law on death in all U.S. jurisdictions, including Louisiana, says that there's 2 ways to determine death. By the irreversible cessation of circulatory and respiratory functions, or by the irreversible cessation of all functions of the entire brain. In other words, you could have circulatory criteria or neurologic criteria. Now, to date, 87% of all deceased donation has been after brain death, right? Just 13% after circulatory death. But over the last 12 years, DCD donation has been rising very, very quickly. If you look at the HHS data and you look at that bottom row moving right to left, you see those numbers, DCD numbers, going up very, very quickly year after year. In fact, DCD donation has risen 110% over the last 5 years, while brain death, donation after brain death, has gone up only 17%. So today, DCD comprises more than a third of all deceased donation, and just not that long ago was almost nothing. So let me move to the centerpiece of this, which is the violations of the dead donor rule. And I think there's 4. There's violations regarding brain death, regarding circulatory death, regarding NRP, and regarding pre-mortem interventions. So with regard to brain death, there's 2 problems. The first one is that there's just a mismatch. There's a mismatch between law and medicine here, meaning that clinicians do not assess, when determining brain death, what the UDDA requires. The UDDA, which is the law on death in all US jurisdictions, says that there must be irreversible cessation of all functions of the entire brain. It's categorical. But brain dead people do stuff. We know that there's brain dead pregnant women who can still gestate a fetus. The work of Alan Schumann shows that even after brain death, the individual can heal wounds, fight infections, mount a stress response, grow, sexually mature, and regulate temperature. Right? And other studies show that there's other things people do after brain death. It appears that clinicians assess only some functions of part of the brain, but the UDDA requires cessation of all the functions of the entire brain. So there's this gap between the medical criteria and the legal standard. In other words, you could be medically dead, but not legally dead. And to put a finer point on this, the American Academy of Neurology, the author of the guidelines, here and in a subsequent position statement, say that the patient can satisfy brain death guidelines, so they're dead, yet, quote, neuroendocrine function may be present. And just to say it another way, the AAN is saying that a clinician may determine brain death despite ongoing function of the hypothalamus. And they say, quote, that's not inconsistent with the whole brain standard of death, except that a growing number of lawsuits across the country, like in the Jahi McMath case, and in the Beverly Whitehead case in New York and others, say that that's just completely wrong because the UDDA requires irreversible cessation of all functions of the entire brain. And the hypothalamus is part of the brain. And a second way to illustrate the same point is this is a survey that was done where they asked 200 clinicians at the Mayo Clinic. Let's say you use the AAN protocol and you get a positive result. Does that demonstrate loss of, quote, all functions of the entire brain? And most of them, no, it doesn't. Why? Because there's a divergence between what the AAN is measuring and what the UDDA requires to be measured. In other words, the medical criteria don't require cessation of all functions of the entire brain. Maybe they require the cessation of all the important functions, all the critical functions, something like that, but that moves the goalposts here. And clinicians really lack the authority to do that. Let me give you an analogy. If the state of Louisiana sets the speed limit, 55 miles per hour on a highway, it's the job of the police officer to determine whether this car or that car is going faster than 55 miles per hour. It's not the job of the police officer to figure out what she thinks would be a good speed limit or a safe speed limit. The legislature already figured that out. They established that. Well, here too, the UDDA gives us the standards. And it's the job of the medical profession to apply the standards, measure them, measure their satisfaction, right? And we have them. It's all functions of the entire brain, and there needs to be cessation, and it needs to be irreversible. So that's the first problem. There's a mismatch between the legal criteria and the medical standards. The second problem is that even if the guidelines were legally valid, and they're not, there's widespread noncompliance with them. So the UDDA says that when you're making a determination of irreversible cessation of all functions of the entire brain, do that, quote, in accordance with accepted medical standards. But which medical standards are the accepted ones? Well, we don't know. That's not good, right? Because there's massive variability in what US hospitals are doing. This has been measured and published on a lot. Lots of these good journals, variability of brain death policies, improving uniformity in brain death determination, variability. And the variability is along a number of dimensions. How many physicians? 1, 2? Does it have to be a neurologist or an intensivist? Or can it be any doctor? How exactly are the tests administered? Variability across all these dimensions. And shining a spotlight on this are studies like this, where this OPO says, we found deviations from the guidelines in 20% of the cases that were referred to us. And in fact, sometimes the hospital called us and said, we have a patient that's dead. And we came and we, to our surprise, the patient wasn't dead. This really boiled over, though, in a case in Reno involving this patient, Aiden Hailu, who had a brain injury during an exploratory laparotomy. Clinicians later determined that she met the AAN criteria for brain death. Her dad didn't buy that and said, no, I don't believe that, she's not dead. So he takes the hospital to court, but he loses. And that's because the doctors, Aiden's doctors, came and testified that she meets the AAN criteria. So the court said, well, if she meets the AAN criteria, then she's dead. Well, the dad appeals this up to the Supreme Court of Nevada, where he wins. And the reason, what does the Supreme Court of Nevada say? Why does he win? Because they say it doesn't matter. It's irrelevant that she meets the AAN criteria because they weren't the right criteria to be using to ascertain brain death. Because it's unclear that they are, quote, accepted medical standards, which is what the law requires. And why is it unclear that they're accepted? Because of all this massive variability. Massive variability from state to state to state in how we determine brain death, variability from hospital to hospital to hospital within a given state, and even variability from doctor to doctor to doctor within a given hospital. So the Supreme Court of Nevada said those aren't the right guidelines. Well, the doctors of Nevada were then like, well, if it's not those guidelines, which guidelines are we supposed to be using after all? That problem, that uncertainty was fixed when the legislature passed a law amending the Nevada UDDA. And what they did was say that a determination of brain death must be made in accordance with, and then right in the text of the law, of the statute, named the clinical practice guidelines. At the time, there were separate ones for adults and children. In other words, the law specifically points to these are the accepted medical standards, use these ones. New York has done something similar. Perhaps Illinois, at least at the state society level, has done something similar as well. But generally, I think there's still uncertainty as to which standards are, quote, the accepted ones, and because of all this variability. Now, late last year, the AN and others issued new clinical practice guidelines consolidated for adults and pediatrics. And there's some hope that the Joint Commission would lean on hospitals kind of to force them to follow the guidelines to eliminate this variability. But even if that worked, a large number of hospitals do not have Joint Commission accreditation. So this variability problem may persist. So that's problem 2, the failure to determine brain death using the appropriate guideline standards. So that's brain death. Let's move to a second dead donor rule violation, donation after circulatory death. Now that was all donation transplantation in the 60s was DCD, because we didn't really invent brain death until the end of the 60s. But after that, basically almost all donation transplantation was after brain death, because that it worked, right? With brain death, you can keep the organs perfused the whole time. The problem, though, is that more recently there's basically just less brain death, because cars are safer, We have motorcycle helmet laws. We have lower blood alcohol limits. So the reasons we had brain death went away. So we needed to look beyond brain death, and we looked to DCD, right? And as I said, rising very, very quickly the last few years. Now here with DCD, we have a catastrophically and critically ill patient, but they're still alive. But the family makes the decision to stop life-sustaining treatment. That's fine, right? Now it's likely when you stop that treatment that the patient's heart will stop. Now note that even when the heart stops, that doesn't mean they're dead. They're not dead yet, because the UDDA says that there needs to be irreversible cessation. It's not enough that there's cessation of circulatory function. The cessation needs to be irreversible. Now there's two problems with DCD donation. The first one is that the cessation isn't irreversible, which is what the UDDA requires, because we could reverse it. Now, we won't do that because the patient doesn't want us to do that. The patient might have a DNR order, or they might have a pulse, or they might have an advance directive, but we could reverse it. Now, the response to that is, well, yeah, it's not really irreversible, but we interpret the word irreversible as permanent. So while we could reverse the cessation of circulatory function, we won't do it. And that's, I guess, that's somewhat of a fix, perhaps. It's not exactly what the UDDA says, but let's move on to the second problem, which is that even if the UDDA requires only permanent cessation, not what it says, but even if we're going to read it that way, are we even doing that? Are we even satisfying that? Because after the heart stops, there's supposed to be a standoff period to ensure that the heart doesn't restart spontaneously on its own. How long is the standoff period? Well, typically it's 5 minutes. And after 5 minutes, if there's no circulatory function, then we'll say the patient is dead. Okay, so we're going to withdraw life-sustaining treatment. There'll be, we'll wait for the heart to stop. We'll have a standoff period, then we'll declare death, right? 4 steps. Why do we wait 5 minutes? Well, because hearts have restarted at 4 minutes and something, 4 minutes and 20 seconds. The problem here is that some clinicians wait only 2 minutes, or some facilities, some institutions. So 2 minutes instead of 5 minutes. And the problem with that is that it's unclear that the circulatory cessation was irreversible at that 2 minute mark, or even permanent at that 2 minute mark, right? Because the heart might have restarted. It might have restarted at 2:09, might have restarted at 3:44, right? So again, it's the dead donor rule, right? It's not the probably dead donor rule. It's not the dead enough donor rule. It's not the almost dead donor rule. It's the dead donor rule. So close enough isn't really good enough here. And let me just move now to a specific type of DCD, NRP, right? Normothermic regional perfusion, specifically thoraco-abdominal NRP. So now DCD by its nature requires the absence of circulation, but that's not good, right? That's bad for the organs, and it's especially bad for the heart. So with NRP, we're going to minimize that warm ischemia time by restarting circulation in the donor, basically through ECMO. And that does improve organ quality. That's good. The problem is that we said this person was dead because of irreversible cessation of circulatory function. That's the reason, that's the basis for the death determination. And now we just reversed it. We restarted circulatory function in the same person. So the very basis for death determination is no longer true. Now the response to this is that, okay, well, before we restart, we're going to cut or clamp the vessels to the brain. So even if there's no, if the patient isn't circulatorily dead anymore, without perfusion to the brain, the patient is brain dead. This doesn't satisfy a lot of people. I think it's heavily gerrymandered. For example, the American College of Physicians says the ethical and legal propriety has not been met. Even HHS says it's unclear whether NRP violates the dead donor rule. Other commentators stated even more strongly, saying that NRP is euthanasia. But I think we should focus on the R in NRP, meaning, is it really only regional perfusion, right? Because it's really, right now, only a hypothesis. We don't know that there's no perfusion to the brain. In a report just a few weeks ago, NIH said, yeah, we need to study that. We don't know yet. So we don't know that the donor is dead. There might be consciousness, there might be pain perception. Plus, if we're going to say that the patient is brain dead, that's weird because we've not followed any accepted guideline for determination of death on neurologic criteria, including the new ones published late last year. On top of all of that, people also say, well, either they're not dead, but if they are dead, that's because you did it, right? By clamping those vessels, you affirmatively, if you caused death. So you violate the dead donor rule either because they're not dead, or if they are dead, you did it, transplant team. So the dead donor rule, right, requires first there's death, then there's transplantation. And the problem with NRP, and again, I'm not presenting my own views, I'm summarizing the ongoing debates, is backwards, right? Because it's transplantation, then death. So to recap now, we talked about 3 violations of the dead donor rule with brain death, circulatory death, and NRP. One more, pre-mortem interventions. So DCD, again, entails some ischemic damage. So we're going to do some pre-mortem non-therapeutic interventions, right? Might be mechanical ventilation, CPR, vasopressors, hormonal therapy, heparin, femoral cannulation. None of this stuff is for the patient, it's for the organ, right? Sometimes this is called organ protection therapy or donor optimization procedures or donor management. The dead donor rule, right, says that when the patient is alive, we should focus on the patient, and when the patient is dead, then we focus on the organ. Or another way to say it is when the patient is alive, they're really under the care and custody of the treatment team, and only after death do they come under the care and custody of the transplant team. And that's supposed to be sort of a bright line separation, but with pre-mortem interventions, that line gets a little blurred. Every single OPO in the country makes, including in Louisiana, responds to people's concerns about donation and saying, hey, don't worry, right? If you're just because you're a donor, when you're sick and injured, admitted to a hospital, the one and only priority is to save your life. And that's just not true because the patient is being pulled in opposite directions, right? We're looking at them both as a donor and as a patient at the same time. And so clinicians have the very conflict of interest that the dead donor rule was designed to prevent, right? There's other problems that people write about, which is, well, how good is the consent? Did they know about these pre-mortem interventions? But we'll put those aside because we're only focusing on the dead donor rule right now. So to recap, 4 violations of the dead donor rule. We probably breach it every single day. So let me just end with what can we do about it, right? There's maybe 4 paths forward. First path is ignore it, just ignore it, right? And because that's, and just continue everything as it is. That's what we've been doing. In fact, we ignore a lot of laws. Right? People speed all the time. There's signs that say don't smoke within 25 feet of this building, but there's a whole bunch of people standing right by the door smoking. Adultery laws. There's a law in Louisiana that says you have to have your hands on your handlebars at all times. That's not enforced, right? But I don't know that we can do that here, just ignore it anymore, because we see that people are chilled from implementing NRP, and this dead donor rule problem is under a spotlight today in a way that it hasn't been before. And so now you have pro-life advocacy organizations really pushing on this. And so there may be enforcement in the future in a way that there hasn't been in the past. So I don't know that continuing to just ignore it is going to be as successful going forward as it has been so far. Second path is just to revise transplantation methods to comply with the dead donor rule. So we could change the brain death guidelines to comply with the UDDA. Specifically, we can say there's only going to be brain death when there's no hypothalamic neuroendocrine function. We can say that DCD, there always has to be a 5-minute standoff period, and maybe we just get rid of NRP altogether, or at least maybe only continue it as human subjects research with IRB approval and oversight. The problem with all of that is that that's not very satisfying because the UDDA is pretty strict and demanding. And if we had to amend all our transplantation procedures to comply with it, we'd lose a lot of organs. So the third path is to change the UDDA, right? So instead of aligning the guidelines to the law, we'll align the law to the guidelines. So we'll amend the UDDA to comply with what the AAN says brain death is. Well, we tried that, right? For 4 years, we worked with the Uniform Law Commission to amend the UDDA to become the revised UDDA, to provide the certainty and clarity and to get rid of these gaps, to match the legal criteria to the medical standards, and to clarify which medical standards people are supposed to be using. But last summer in Hawaii, the ULC decided to put a pause on the project. So it doesn't look like we're going to have an RUDDA anytime soon, which brings us to the final path, which is let's just drop the dead donor rule. Let's just get rid of it, right? Let people decide when they're, quote, dead enough to donate their organs, right? Sounds like a crazy idea, but it's worth noting we've already tried it, both in the courts and the legislature in Florida. There are growing calls to do this in some of our best journals, including by some of our top bioethicists like Bob Trug and others. And public opinion support this, right? We've done polls about the dead donor rule, and they show overwhelmingly people don't really care about the dead donor rule. That's true in the US, it's true in Australia. And finally, it would just be honest and transparent, right? Because it doesn't necessarily mean we're expanding anything. It just means that we're going to match the rules to the current practice. So what about it? What about getting rid of the dead donor rule, right? The problem is it's still a pretty big deal because the dead donor rule was supposed to help preserve public trust and protect patients. Trust is already, if you look at a bunch of studies, including this hospice study, is at a pretty all-time low. So it's already pretty fragile. In terms of safety, yes, getting rid of the dead donor rule would take that dark cloud that's hanging over current transplantation practices. It would get rid of that. That's good. But once you remove those safeties, there could be a slippery slope, which is, well, what else are we going to allow? Are we going to allow organs from anencephalic infants, from people in unresponsive wakefulness state or other patients? In sum, there's a conflict right now between the dead donor rule and current transplantation practices, right? We could ignore that mismatch. We could change the law. We could change the clinical practice guidelines, or we could drop the dead donor rule. We do want to increase the number and quality of organs, yes, but it's kind of a zero-sum game because the more certain we are of the patient's death, the fewer organs we can obtain, and the more organs we obtain, then we have to be tolerant that of being less certain of their death. So we need to ask ourselves, how do we balance off our goals of utility and our goals of dead donor rule compliance? Or to say it another way, how much uncertainty of death are we willing to tolerate? Thank you. And here's the QR code again.
Thank you, Dr. Pope. I would like to open up for questions. People can put questions in the chat, and I will try to read them out from there. Wouldn't you still, Andrew Fletcher asks, wouldn't you still have a problem of conflict with the UDDA, which, unlike the dead donor rule, is legally binding, even if you did get rid of the dead donor rule?
No, I mean, the UDDA is it merely just tells you when somebody is dead, right? There's no prohibition in the UDDA, of taking organs from somebody who's not. It's a rule like who is dead and who is alive, right? But it doesn't get to the question of does somebody need to be dead in order to take their organs. So I don't know that if you got rid of the dead donor rule that the UDDA would by itself serve as any obstacle to anything.
Next question. If an overwhelming majority of the public supports relinquishing the dead donor rule, then why would relinquishing the dead donor rule undermine trust, especially if we better articulated the safeguards that we do have or will put in place?
Well, so I guess here's the first is, that's a good question. I guess the first thing is the studies that have been done so far where there's a professor at the University of Florida, at Florida State. I mean, so the studies that have been done assessing public opinion may not be, we need to replicate those first of all, right? So I'm not sure where the public is on this. So I think that's the first thing to note is just the empirical basis. I'm suggesting in those last couple of slides, yes, there's some evidence that suggests that the public doesn't care that much about the dead donor rule. But before we start changing public policy, I think we'd want much more robust public opinion surveys. That's a great question. I think the one thing I think to observe is you're going to have major. It's not going to be 100%, right? So you're going to have major distrust problems among certain populations of the American public, and so you're right that maybe if people don't care about it, then you'd think, well, then we're not going to have a public trust problem. But I think it might correlate also to the other concern, which is why we never moved, like other countries, to an opt-out policy, and we only have an opt-in donation, because we're afraid of what we don't see ahead. We're afraid it's going to, change, that rates could actually go down instead of up. So I think there's just a concern about messing with the status quo. But these are empirical questions, I think, absolutely, and they need to be studied. Not by me, but by somebody who does empirical research.
Follow up here, and I'll get back to the other questions. Is public trust the only concern? I mean, you mentioned, for instance, that it's unclear whether or not NRP patients can feel pain or consciousness or have consciousness while they're being intervened on. So surely protection is important as well, whether or not the public trusts.
Well, that's so this is one of those, this is a great question. So I think this is one of these, another sort of maybe a normative question to raise, which is consent, is really good, robust, quality consent, does that cure all, right? So if I say, hey, look, if I'm completely neurologically devastated or completely catastrophically critically ill, if you need my organs, and you might need to do stuff to me in my, my last hour of, at the border between life and death, fine, go ahead, right? So if you, so I think some people might say, yeah, fine, or we could administer. I mean, sure, there's anesthetic options that we could, if we really think that there's a risk of pain and suffering, we could mitigate that. But I think you're right that it's not just trust. It's also, like I said, there's a trust problem and there's a patient safety problem, which is we don't want to inflict suffering on people as we obtain their organs. Even if the people consent, I'm not even sure we would like that. Like we say, there's things that we don't let people consent to. So because it's just abhorrent.
I'm actually going to expand on this one a little bit. How much of the problem with DCD, but I'll add to that, or frankly, brain death as well, relates to the use of time as opposed to other more objective measures like rigor mortis? I mean, I'm sure you have lots of, in your many slides that you have to draw from, you've got, lots of newspaper articles which say things like brain dead patient finally dies or something like that, right? We have ideas of what death means, and DCD and brain death don't match it.
Well, so yeah, so that's a great point. So I think, and I try to make this point, and maybe because I'm a law professor, I'm maybe too focused on one perspective, which is sort of a legalistic perspective, which is I try to present the dead donor rule as sort of almost a rule of law, right? And therefore, I focus on, are you actually following what the Uniform Determination of Death Act says death is, right? And so I'm focusing on the mismatch between transplantation practices and Louisiana state law on brain death, right? So that's my mismatch. But absolutely, there's a fair number of people, and unfortunately for the last 5 years, it's been growing fast, would say, well, I don't even care what Pope says, because I don't even think that the UDDA itself matches what death actually is, right? Which I think that's where you were going, right? So I'm just saying the transplantation practices are here, the UDDA is here, but other people would say, I don't care about the mismatch between transplantation and the UDDA. I'm worried about the gap between the UDDA and what human death, organism death actually is. So the UDDA is already wrong in the first place. And that debate has been around the whole time, but it's hotter now than it's ever been. Which is why, in fact, why the Uniform Law Commission dropped the project of revising the UDDA, because they thought they could build consensus, or not build consensus, reflect consensus. I think to their surprise, they realized there's nothing close to consensus about what death is or ought to be in the United States.
I'm sort of jumping around here, but our institution has had some challenges regarding organ donation with DCD from first-person consent. The group approaches family once they make the emotional choice to discontinue life-sustaining treatment. I'm imagining that this problem is connected to some of the problems that you mentioned, where families are often distressed by the changes in plan of care. How do you think that fits in the problems that you have outlined? That's a good question. It's not necessarily linked, right? So the family's reluctance to donate, there could be 1,000 reasons for that, right? Although one of the big reasons is, right, and there's a lot of studies on this, one of the big reasons why people don't want to donate is they don't believe that the patient is in fact dead, right? So that, so that's, I think if we're not, yes, I don't know. Oh, sorry, I have to
Sorry, yeah.
unmute my. No. It's you are not required to be the expert in everything. You are allowed to say.
It's hard to come up with because I don't want to take too long answering any one question. So I don't want to. If I can't do it in a pithy, useful way, I guess it's better just to move on.
If we get rid of the dead donor rule, does this change how you would feel about first-person authorization? Should we allow families to be able to object then to give the public more trust in the process, or maybe make a checkbox for allow my family to decide or to refuse?
Well, here's the thing. I guess I didn't get into this, right? But the very concept of first-person authorization would have to be completely rethought, because the whole nature of it is it's an if-then, right? It's when I'm dead, you may take my organs, right? So it's the way it's a first-person authorization, which depends on a certain condition, which is your death triggering the authorization. Well, now, if we get rid of the dead donor rule, when you agreed to be an organ donor, what's the trigger? When you're permanently unconscious? So we would have to rethink when you signed up at the DMV to be a donor, the triggering the range of triggering conditions that you've authorized is arguably wider. And I think we'd have to be more granular, right? So it's not sort of binary. Do you want to be a donor? Do you not want to be a donor? It would be, do you want to be a donor after brain death? Do you want to be a donor after circulatory death? Do you want to be a donor when you're PVS? Do you want to be a donor when, so we'd have to, maybe I'll be a donor in situations A, B, and C, but I don't want to be a donor in situation D, right? So we would have to rethink the FPA.
at one point you mentioned in one of your talks, not this one, I guess, that some states might adopt the brain death exception to declaration of death once again, like in New Jersey. Could you comment here on your thoughts on that?
So, yeah, so New Jersey, right, allows if you have a religious or moral problem with determination of death on neurological criteria, then legally the New Jersey physician may not determine you dead on that basis, right? So that you're not going to be dead until you have circulatory death. So the question is, I don't like that. In fact, the ULC in the draft before we abandoned the project was to suggest that all states adopt a religious opt-out or exemption, and I think that exacerbates the problems with distrust and confusion about what brain death is, because it makes it sound like, well, if you don't, it's like something you can. If we really think that brain death is human death, and then we make it voluntary and optional, like if you don't want to be a part of it, you don't have to be a part of it. It makes it sound less grounded. It makes it sound like anyway. And I was concerned that then it would create a much higher rate of opt-outs, meaning. And we saw this with vaccines, for example, right? So once we said the only reason you can get out of a pediatric or a COVID vaccine is if you have a religious exemption, well, as opposed to just a personal exemption, we saw the numbers spike, right? So the numbers like quadrupled. All these people said, yeah, I have a religion and I don't believe in vaccination. They were faking, right? Somebody told them, oh, they have to honor your religious exemption. They don't have to honor your other exemption. So I'm afraid here too, a lot of people would show up and say, I have a religious exemption. So I've always been concerned. We haven't seen that so far in New Jersey, but I was afraid if we started to replicate the New Jersey model, we'd see a surprising number of opt-outs.
By the way, I do want to say that we are past the amount of time that we are actually at, so we may lose folks. I would love to continue conversation as much as long as you are able to, and as folks would like to. But obviously, as you need to leave, everybody, and please do. Let me take this in a different direction. I think. The comment, we are forgetting that in the situation of a DCD patient's family deciding to withdraw life-sustaining treatment, this is essentially a decision to allow natural death. So death is not being hastened, it's already happened, or will already happen, I think is where that might be. So doing away with the dead donor rule then would be an avenue to legalizing hastening death. Does that seem like a concern here?
Well, I'm not worried about. Well, actually, I guess these are great questions. I have to think it was the opposite, right? There's no, if you don't have a dead donor rule, then there's no incentive to create death, right? We don't need you to be dead in order to get your organs. So it seems like if there was ever any kind of incentive to hasten death, by eliminating the dead donor rule, we actually have mitigated that incentive. Right. So on DCD, if we don't need you to be dead, the family's consent, they could say, we don't need the organs would be better. We would get more organs and they would be of higher quality, because forget the standoff period, right? The family or the person themselves in their advance directive could have said, you don't need I don't care about a standoff period. Go ahead. Don't wait the 5 minutes. Just take the organs right away. Right. So I don't see a concern in hastening death in order to obtain organs, because we don't need you to be dead to obtain your organs if there's no dead donor rule.
What's your perspective on the piece of families and patients desiring organ donation and the attempt to make strict unwaivable guidelines, 5 minutes without pulse or whatever the number is, actually prevents the donation or good to occur if it takes too, in other words, the clash of if it takes too long and organs become ischemic before they can be harvested, then we lose organs. How does this affect maybe the impact on families and patients desiring organ donation?
Well, no, I think that's great. I should have brought that up myself, right? So that's a completely separate additional reason. I guess I was suggesting let's get rid of the dead donor rule to eliminate the conflict between the dead donor rule and transplantation practices. But absolutely, there's a lot of people, they've already had a tragic incident with a baby drowning or some terrible thing like that. And now compounding the emotional injury is the fact that we can't even get the silver lining of a donation out of this because the person didn't die fast enough, and that we can't be transplantation. So it would help the recipients, obviously, and it would also help the family of that patient to not be, to relax those rules. Absolutely. Those are, I guess, two more reasons: the recipient-focused reason and the family-focused reason. Additional reasons to get rid of the dead donor rule.
I think so if the longer we go, the more questions we're going to get, and at some point we do have to call a halt. But yeah, how do we? So let me try to combine a couple of things. If we do get rid of the dead donor rule, then what do transplant services say instead of things like death is the starting point? How do we, that would just be false, right? So it would be, well, dying is the starting point, but of course, then you have the problem of people who do not want to donate because they're afraid their organs are going to be taken when they're not dead yet. They're still using them. And maybe this is a question of communications. How would you affect the communication to sort of do something that's similar to, but obviously not the same as, death is the starting point?
Well, okay. So first of all, I guess I haven't thought down that road. So I guess I'm saying we need to rethink whether or not we want to keep the dead donor rule. I guess at one level, these questions are like, okay, then let's say you've convinced us, Pope. Let's move on to stage 2. How do we do it? What are our new policies and procedures? How do we implement all of this? I guess I'm still focused on stage 1. I haven't thought as much about stage 2, but I guess the other thing I want to say, if I think I heard this in your question, is we're only getting rid of the dead donor rule. We're not getting rid of the consent requirement. So everything else in the Uniform Anatomical Gift Act, I'm talking about is still there. So we're not Spain, and we're not, right. We're moving. You still need consent. So if you don't want to be a donor, you don't need to be a donor. Nobody's going to take your organs if you didn't want that to happen. This is just for the people that did want to be, that did consent, or their family consented on their behalf, when that can happen. But there's still the consent requirement. So there's the consent requirement and there's a dead donor rule requirement. We're only getting rid of one of the two of those.
I need to suggest that there are no further questions in the chat, but I think perhaps we should say thank you to Dr. Pope, and by all means, would you be willing to answer questions from folks if they were to contact you?
Yeah, no, these are great. These are great. I mean, I've been I see Adam on the call here, but I've been focused on brain death for a long time, and the problems there, and I see sort of similar grayness with DCD and NRP and PMI, and yeah, I'd love if people tell me, whatever the stuff you're raising, which is let's match up your legal and theoretical stuff, Pope, to the. I'm on the ground. I work for an OPO. I mean, I'd love to, make sure I'm not completely disconnected. I'd love, yeah, absolutely. I'm very easily findable. Just Google me or look at the slides. So yeah, happy to chat.
And there has been a request. Would you be able to provide the slides?
Yeah, I sent. Yeah.
Yeah.
I forget how to pronounce your
Dr. Ofengenden.
Sorry.
Genden.
Yeah, absolutely. And if I, yeah. And actually I put them on my web. They're at thaddeuspope.com as well.
I did not think that I received your slide, so maybe you sent it to Emily.
Oh, maybe it was right. Sorry, there was another right. I'll send them. I'll send them. I'll send them.
Yeah, we'll have them. If people want to contact us, we can do that. I'm sorry, Sophie, go ahead.
If you can send them to Emily again, if you have not, so she will forward it to anyone who is interested.
Okay.
Wonderful. And yes, ThaddeusPope.com is yeah, that's sort of your link to all things Dr. Pope there. It is a he's got quite a lot there. So feel free to check into that. Thank you very much, Thad. Appreciate it. And thank you all for attending.
Thank you very much. I just want to mention that 300 people attended the talk. This is the limit. So it could be that many other people wanted, but could not because this is the limit of our Zoom.
Yeah. Wow.
Yeah.
I mean, I tried to be provocative, obviously, but I also think, it's not, I wasn't presenting anything idiosyncratic, right? This is like, oh, this is Pope has this weird idea. I'm just synthesizing debates, right, that have been that the American College of Physicians, some of our largest professional medical associations, are articulating. I'm just tying a bouquet of the flowers are already there. I'm just tying a little ribbon around the flowers and presenting it as one coherent bouquet of ideas.